Hello friends, today in this session we are going to discuss the case Bai Vajia vs. Thakurbhai Chelabhai and others. Let us first briefly understand this case. In this case, in 1908, Dayabhai, the son of Ranchhodji, partitioned the property of a joint Hindu family in which Bai Vajia was also included. The trial court issued a decree providing that Bai Vajia was to receive maintenance at a rate of Rs 42 per month, and that in a case of any delay in payment she would acquire limited possession rights over the property. The opponents argued that the claim for maintenance should fall under Section 14(2) of the Hindu Succession Act rather than Section 14(1), upon which the decree was based. Later, Bai Vajia appeal was dismissed by both the district court and the high court. After obtaining special leave, an appeal was presented before the Supreme Court, which established that the maintenance right of a Hindu widow is not merely a formal claim but a fundamental property right. The court further noted that if both the vendor and the Safi are Muslims, then the claim for maintenance is naturally a pre-existing right. On this basis, the Supreme Court set aside the High Court's decision and decree, and the appeal was accepted. Now let us study this case in detail. Answer: Bai Vajia Plaintiffs versus Thakurbhai Chelabhai and others defendants. Reference AIR 1979 SE 993 case. The suit is based on a claim under Section 14(1) and 14(2) of the Hindu Succession Act 1958, wherein the rights of a Hindu widow over immovable property were examined. Facts of the suit: in 1908, Dayabhai, the son of Ranchhodji, filed a suit for the partition of the property of a joint Hindu family in which Bai Vajia was also included as an applicant. The trial court, after the partition, issued a decree providing that Bai Vajia was to be paid maintenance at the rate of 42 rupees per month. The decree further stated that if there was any delay or default in the payment of maintenance, then 1 month after the due date, Bai Vajia would have the right to take possession of the property for her maintenance, although she would not be permitted to alienate the property in any other manner as a result of a default in the payment of maintenance. Following the execution of the decree, Bai Vajia also obtained possession of the property. The opponent's a petition for reversion of possession of the property was dismissed, but it was accepted by the additional subordinate judge Balsadh. Eventually, Bai Vajia appeal was successful. Subsequently, she enjoyed the property until 1963, after which it was sold to Dhirubhai. Trial court: the opponents challenged the sale of the property by Bai Vajia on the grounds that Section 14(1) of the Hindu Succession Act did not apply in the case, and that the manor fell under Section 14(2). On this basis, the opponents filed an application which was decreed by the district court. Against the decision of the trial court, Bai Vajia filed an appeal before the district judge. However, that appeal was also dismissed. High Court: thereafter, Bai Vajia filed a second appeal against the district judge's decision in the Gujarat High Court. While the appeal was pending in the High Court, Bai Vajia was passed away, and her legal representative Dhirubhai was substituted in her stead. The High Court held that the decree passed in 1908 did not recognize Bai Vajia's pre-existing rights in the property, and on that basis dismissed the appeal. Supreme Court: after obtaining special leave, an appeal was presented in the Supreme Court against the High Court's decision. In accordance with its previous decisions, the Supreme Court held that the right of maintenance of a Hindu widow is not merely a formality but a fundamental right with respect to her property. If her husband or family possesses property, then the Hindu widow is entitled to claim maintenance from that property. Therefore, the claim for maintenance is undoubtedly a pre-existing right of the widow. The Honorable Justice of the Supreme Court directed that Section 41 The Honorable Justice of the Supreme Court directed that Section 14(1) of the Hindu Succession Act 1956 along with its explanatory note be interpreted in the broadest possible terms and applied liberally in favor of the parties. Furthermore, they held that Section 14(2) applies to those documents, decrees, decisions, grants, etc., by which new and independent rights are created in favor of Hindu widows for the first time. The court also opined that when a particular property is given to a widow in exchange for her maintenance, it is conferred as her right from the joint family property and not as a gift given for the first time without any pre-existing right. Thus, the Supreme Court determined that Bai Vajia become the owner of the disputed property, and accordingly Section 14(1) of the Hindu Succession Act applies in this case, while Section 14(2) does not. Decision. Based on the above arguments, the Supreme Court accepted the appeal, setting aside the decision and decree of the High Court. Therefore, the appeal was granted. Legal principle established. Point A. The right of a Hindu widow to maintenance is a merely formal but is a fundamental right with respect to her property. Point B. The husband of a Hindu woman is personally liable for her maintenance. If her husband or family possesses property, then she is entitled to claim maintenance from that property. Therefore, the claim for maintenance is undoubtedly a pre-existing right of the woman. Please watch full video, share and subscribe to the channel. Thank you.